Going to be somewhat interactive, and if you can please interrupt me if you do have questions. Let me know how I can clarify things if I go too fast, and I'll do my best to keep it as straightforward as possible. I want to thank Marta personally. I've known Marta for a long time, and I didn't realize that this was her first time publicly kind of explaining and acknowledging what happened with her son, with her family. And I am just inspired by that level of trust that she's placing in us to allow her to open up like that. And I think we need to recognize, and I know that we all, in our own way, are doing things like this. So Marta, thank you. And it really helps, I know, a lot of people when you open up and there are similarities that they're feeling as well. So thank you for that. I want to expand just a little bit on my introduction. My name is David Crackey. I was an attorney for 28 years until 60 days ago when I went inactive. So while I'll be talking a lot about things today, I'm not giving legal advice. Right, Gary? Right, Jim? Is that right? But at the same time, I'm hoping to be as informational as possible. I was appointed recently to be Oregon's Brain Injury Advocate Coordinator. And this is pursuant to a federal and state grant. I am now working through the Center on Brain Injury Research and Training at the University of Oregon. I was a member, an expert consultant on the Governor's Task Force. Fern was just a driving force on the Governor's Task Force. And through that process, the task force process, we identified needs among the brain injury survivor community, and that includes family members. What is going to make that experience easier? How are we going to fix it in the ways that it needs to be fixed and made better in the ways that already exist? There was a kind of the handbook that was held up, and this is what Marta received when she left the hospital. And it's a little much in my mind to think that someone with that level of trauma in her life, not to mention obviously family members and certainly not to mention her son, that she is somehow going to now read this 15 or 20 page pamphlet, understand everything, and so, lo and behold, everything's going to be better, and all of those services and support groups and what have you that are out there are just going to fall at her feet, and it will be a smooth process. We know that that is not the case. We know that one of the most important identified gaps that we figured out through the brain injury or through the Governor's Task Force was that there is not a clear roadmap. People leave the hospital in a very high level of anxiety, and they do not know what to do next. One of the areas that we are really focusing on right now, and I'm getting a little bit ahead of myself, I'm going to mention it briefly, is the idea of having, in the Governor's Task Force, we call them navigators. In other states, they are called resource facilitators. And these are social workers, for the most part, whose jobs it is to literally call those families of brain injured, whether it's acquired or traumatic, who come out of this hospital setting and need advice. They need help. And it can't be just a cold booklet. It has to be a warm interaction with another human being who actually is clear and has knowledge that will be useful. So one of our significant tasks, and again, I've been on this job for all of 60 days, but what we have already realized is that there is tremendous economic benefit to the state if we do, in fact, incorporate or create this program of resource facilitators. And I am hopeful that we will be able to leverage that economic data that we are creating with the legislature and with the agencies down in Salem to create this program statewide. It's one of my primary goals right now because the return to work statistics are so much greater when there are resource facilitators helping the survivors through this difficult process, and that of course leads to revenue both into the pocket of the survivor but also into the state, and we know that the state anytime you talk about increased revenue, they are going to listen. So as was mentioned by Dana in the introduction, I got started in this field in approximately 2006 when I was asked to join the board of the Brain Injury Alliance of Oregon. And at that same time, Ralph Conrad, who was Max Conrad's dad, came into our offices and said there has to be something to do with regard to the concussion, or in Max's situation, second impact syndrome, the second concussion that he suffered repetitively 1 week after the next, or just two within a 1 week time span playing high school football. And it led to just a cascade of neurological problems. He was in a coma for, I believe, 4 months. He was on his way to Cornell. He was a 4.0 student before that. And yet he was allowed to play football at a time when he was exhibiting signs, symptoms, and behaviors consistent with a concussion. And we know at that point that the brain is much more vulnerable to a second impact. And unfortunately, that's exactly what happened. The game film is not startling. For the second concussion, you wouldn't hardly even notice that anything had happened. And yet when, it was just a routine play, if you will, in that sport, and I can go on about that later, but nonetheless, it was a significant enough blow that his life changed, and changed for the worse, and tremendously, just dramatically. It starts like that with the legislative process. There's always that personal story. There's always some person, at least in my experience, who has had a wrong, who was exposed a glaring problem in the system. And in this case, it was the coaches were not educated. They didn't understand the signs, symptoms, and behaviors of a concussion. They didn't understand that they should allow that or require that player to come out, and to require that player not to return to the field until he or she has been cleared by a qualified healthcare professional. We were, as was mentioned, Oregon was the first state to enact a concussion law, the first. We enacted ours on July 9th, 2009. Washington was second. Washington and Oregon, it's been this weird kind of rivalry that we have going back and forth. And my goodness, I made a comment that was picked up in the Oregonian last year about the fact that Oregon's law was the first enacted. And I had guys from Washington calling me up and threatening to call the Oregonian editorial board and demand a retraction because they were first. It's like, oh my God, people, aren't we all working toward the same thing? But as an attorney, it also got my, kind of my ire up a little bit, and so I dug into it and found out that in fact, yes, we were the first. Hooray! And not that I care. But regardless, within about 4 years, every state in the country had passed an analogous law. We were on the crest of a wave at that point. As Dana also mentioned, we had to follow that law up with what is called now Jenna's Law. Jenna Sneva is a wonderful woman who lives in Sisters, Oregon. At the time of her 11th concussion, let that sink in for a second. At the time of her 11th concussion, she was training for the Olympics in a sport called skier cross. And if anybody, I'm a skier, and I don't know hardly anything about skier cross. It's a new kind of phenomenon within the skiing community. And I liken it to kind of roller derby on skis, where 5 skiers all start off on this course with a lot of whoop-de, little jumps and bumps and big bank curves that are kind of reminiscent of those old Hot Wheel curves. And these skiers, 5 skiers, just, it's first one down. It's the first one to the bottom wins. And it gets very violent. There's a lot of very hard spills. They're taking jumps where they're flying 40 feet at a time. And unfortunately, and they're on very hard snow. And unfortunately for Jenna, she kept going down, hitting her head. And she finally was referred up to OHSU, where she entered Dr. Chestnut's concussion clinic. And Dr. Chestnut at that point basically drew the line and explained to her what fire she was playing with here and how she really could not afford any further concussions, because already the effects of those multiple concussions were becoming very apparent in terms of reduction in cognitive abilities. And so we recognized by that time that Max's law, being the first law, was not the complete law. And that's a political reality that we just cannot typically bite off eat the entire apple. There's always portions that are left uncovered whenever you're the first one through the gate. And we realized that Max's law covered high school sports. We realized that there were players throughout the state who were playing recreational soccer, for instance, club sports, CYO, OYSA, you name it, all of those sports that are not, all of those leagues that are not affiliated with high schools themselves. And I remember so vividly the conversation with Jenna and her mom in my office, where I explained to Jenna that I wanted to use her as the face for this name, or for this law. I wanted her to be the story, the backbone of this law, the reason why we needed this law. And Jenna, in what I later found out was nothing more than sheer courage, sat in my office for the hour that it was when we were talking about her being the face of this law, and she agreed, her mom agreed. I thought I was aware of the situation. I wasn't. Jenna, when she left my office, and she's recounted this, I'm not disclosing any confidences here, Jenna went home and isolated herself for about 3 days in a dark room, because the stress of that meeting, the stress of what she had agreed to, was so overwhelming for her that it was all she could do to, number one, get through the meeting. And when she did get through that meeting, it was just a real significant collapse for her. When I found that out, you can imagine, I really reevaluated how I approach clients, friends, colleagues who are TBI survivors, because it's critical that I am aware, to the extent that I can be, what the survivor is going through. And that is kind of leading to where I'm going to go with this presentation. Again, I really encourage people, if you have a question as we go along, raise your hand and I'll get to you. What we just heard from Marta is that when a brain injury strikes, it strikes suddenly, it's typically extremely unexpected, immediate health concerns, there's turmoil, sympathy issues, there's pain, there's grieving. Marta referenced loneliness, isolation. Those are absolute realities when you're dealing with this, either certainly as a survivor, but also as a family member. There are language issues that have to be considered. There's cultural issues that have to be considered. This is a brand new area for anyone who's thrust into it for the first time. There's a lot of confusion. Where I want to go right now, however, is after we have the injury, after there's stability, and after those deficits are understood, then the question becomes, now what? And there is no single answer to that question. So I'm going to focus, at least in part here today, on some assumptions. And I may not be hitting, a highlight for people that are here today, but there are certain assumptions that are going to at least lead me into where we can go with that. And so the first assumption I'm going to make is that there was a third party that was negligent, that did something that caused that injury. Now, unfortunately, in Marta's case, that doesn't seem to be what happened. But as an attorney who represented brain-injured individuals for 28 years, that's why people came to me, because there was, in fact, a third party. There was someone who did something that caused that injury. Now, when that happens, talk about adding confusion to confusion, because no one really instinctually knows what happens in a lawsuit or even how to begin that process. What do you do? There's attorneys on both sides of that fence at that point. I was what was called a plaintiff's attorney. The other side, the attorneys, and let me let you guys in on something that you probably know, but it's really important to remember. Our system of law here, of litigation, is adversarial. There are attorneys who represent the plaintiffs. That's the plaintiff's bar, if you will. And then there are attorneys who represent the defense, and that's the defense bar. Attorneys are tasked with zealously representing their client. That's an ethical imperative. That is an ethical requirement. We have to zealously represent our client. So for me, that means zealously representing the injured party and their families. For the insurance defense attorney, that means zealously representing the interests of the insurance company, for instance, that is being asked to consider making payment on the damages that have been assessed, both the economic and the non-economic damages. So those attorneys on both sides of that equation have an absolute duty to do everything they can to best represent their clients. And we operate at a very high level in terms of expectations, in terms of where we're going with a case, in terms of just the intellectual rigor that's required to effectively represent someone. Yeah.
I was just going to ask David, when you talked about the different timing and represent, as an example for like Bax's law or even for this new, do you have to make conjectures and the insurance companies have to try to say this is going to continue for the future and it's going to be a certain thing, like as those who have brain injuries and have a level and we don't know whether it's going to stay the same, get better, get worse, are there precedents or something that you
Sure.
look for?
And thank you for that. The question, if you didn't hear it, is, in a nutshell, is what considerations do I, as a plaintiff's attorney, look or consider as appropriate damages in any given claim? And those damages fall under two categories. Number one is economic. Number two is non-economic, or they call it special and general damages. And we absolutely, as a plaintiff's attorney, are looking at every aspect of damage, from the property damage, and I'm a little bit ahead of myself here, property damage, the loss of enjoyment of life, which is kind of that non-economic damage, future economic damage, which would include future medical treatment that's required, future lost earning capacity, because if the injured person had a career and now they can't do it, that's a loss of income or a loss of future earning capacity. So we are absolutely on both sides assessing the extent of those damages and what that really what that means. And those types of analyses on both sides really gets into the negotiation that happens back and forth as the litigation process moves forward. The first question that always comes to mind is, okay, who's going to pay for this? Where are these resources coming from? And so if in the situation where it's an auto claim, an auto collision where someone else was at fault, hopefully there's some auto insurance there on the side of the defendant, the person who caused the collision, for instance. Also, and this is actually a good time, I hadn't even considered doing this, also the injured person is going to look towards their uninsured or underinsured motorist coverage. And on everybody, whoever is a driver here, whoever owns auto insurance, there is a little portion on your declaration page that says UM/UIM. All we are inundated by, apparently, whenever I watch TV, are commercials telling us how much we can save. Make a phone call and we can save you 15% on your car insurance. Well, what they're not telling you, I think, and I'm just speculating here, is that the savings means that we're reducing your coverage. And if you need that coverage later, sorry, you saved your money with your premium savings, but you don't have that coverage now that you need it. I will encourage everybody to take a look at your UM/UIM coverage, which is, again, underinsured or uninsured motorist coverage, and consider that your own safety net. You'd be surprised how inexpensive it is to actually increase that level, but that is the money that's protecting you and everyone who is in your vehicle. So I would urge you to take a look at that. If you have an agent that you can talk to, start that conversation, at least so you're educated about what that means. The second area that we have as mandated in the state of Oregon is PIP, and people probably know PIP insurance, called Personal Injury Protection Insurance. The state mandates that that level now is, I believe, $20,000, and that's per person in the car, and that's a no-fault insurance policy, meaning even if I do something negligently, I still have that coverage for, as defined, reasonable and necessary medical treatment. I have increased my PIP coverage up to $50,000. That's again per person, whoever's in my car. I did that at a time a number of years ago when my daughters were young and I was coaching soccer and I was driving. It was my minivan years, and I invariably had a minivan full of young soccer players, team members, and I knew some of those team players were uninsured. I just knew it. And so I wanted to make sure that if they were in my car, and certainly my family and myself were kind of in that mix, if they were in my car and God forbid something were to happen, they would have that coverage. And I increased my coverage up to $50,000, and from 1 year up to 3 years after the collision. So another area that we might want to look at with regard to, is there another person who can help pay for my damages, is whether or not that was an on-the-job injury. That's another very common place where people get injured. And then you fall into the workers' comp system, which is an enlightened system, an enlightened program, but it's also going to be a fight, and you will need to get an attorney to help you through that process. There's a real interesting, workers' compensation is typically the exclusive remedy if a person is injured at work, during the course of work, what have you. But there is another little twist in there that says that if you were injured at work as the result of some other third party's negligence in some form, then you can also go after that third party. And that's known as the employer liability law. We had my firm, the Nichols Law Group, we had a case out of Corvallis where a gentleman was a worker at one of the Hewlett-Packard remodels at one of their facilities down there, and he was on a scaffolding, and one of the third-party contractors had not properly done the railings around the scaffolding, and our guy fell off and unfortunately landed on his head and suffered a real significant brain injury. Our first impression was, well, this is a workers' comp situation. That's the exclusive remedy. But then through the discovery process, we identified this third party, and we were able to pursue a claim against this third party, which it creates a pool of damage, a pool of money that is available that would otherwise not be available through the work comp system. I have a note here, preservation of evidence is really important. The last thing that you want to be thinking about when your son is in the hospital, when you are faced with this emotional trauma, when you are dealing with things that you never wanted to deal with, The last thing that you really want to think about is, okay, I have to think a year ahead, and I need to preserve some evidence here. I mean, it's almost ghastly for me to even talk about this type of thing because it's so it just sounds bad. That you have to be sitting there in a hospital setting, for instance, when your loved one is in this dire situation, and I'm here, standing here right now, advising that you have to think about evidence. I mean, I hate, forgive me, but it really is important to preserve what's going on. Taking photographs of the person in the hospital, making sure that there are witnesses, if there's a police report, making sure that, that there is in fact a police report. A lot of this stuff the attorney is going to do for you down the road, but a lot of it the attorney can't because, let's face it, you're not going to go out and immediately get an attorney, or typically, I know that some people do, but typically that's not the norm. But you want to think in terms of preserving the story of whatever happened so that you can explain and tell that story later on in the future. And so, I talked about photos, making sure that if there are witnesses, that they are identified, things along those lines, that just, you want to think in those terms. I have a note here that you probably do not want to talk to anyone from the other side, an insurance adjuster or representative who might want to take a statement, things like that. I would advise that you talk to an attorney. Now, you do have a contractual obligation to discuss these things with your own carrier. That's something that you have in your contract with your insurance carrier, and you do have to cooperate with them. But you don't have to go and when you're in this hardship, stressful situation, and now all of a sudden also try to explain this to someone who does not have your interest at heart. It is a battle with insurance, especially with traumatic brain injury, because I know that this is going to be somewhat controversial, but there's almost a presumption of exaggeration, of malingering, of a somatoform disorder, of minimal effort. I find these presumptions that I hear that I heard for years and years and years, coming from the defense bar. Again, just doing their job. This is what they do. This is what I would do if I were in their shoes under that ethical imperative to zealously represent my client. But within the realm of traumatic brain injury, where so much of what we are dealing with is subjective, and there's a different, and by subjective I mean it affects the individual kind of personally, and you can't necessarily measure it on an MRI. Most traumatic brain injuries, unless there's a brain bleed, something that leads to a midline shift, something that they will find on a CAT scan or an MRI that indicates typically a very acute situation where they have to go in and relieve pressure through a craniotomy or something along those lines. Other than that, as anyone who is a survivor or a family member of a survivor knows, many of these damages that the individual suffers are extremely personal and not necessarily subject to measurement, except, for instance, with a neuropsychological exam, where they will go through a battery of exams to try to identify deficits in cognitive function, executive function, short-term, long-term memory, recall, things along those lines. And if anybody's been through that very exhausting battery of tests, you know what I'm talking about. But there is an effort on the other side to kind of diminish those damages or to assert that there are other causes other than the brain injury. And so you need to be aware of that as you continue through this litigation process. The litigation process has a number of kind of mileposts along the road. There's settlement. If you're able to get the case settled, settlement typically is defined as a situation where both sides feel like they got ripped off. The defense paid too much and the plaintiff didn't get enough. And that usually is what it takes to resolve a case like that, because again, these are hard-fought cases. Now, if you don't settle and you get into litigation, then you have to understand that there's a discovery process. Discovery will include depositions, which can be very stressful. Those are under sworn statements, under oath with a court reporter, and some pretty rigorous questioning. Independent medical examinations come into play at that point, where doctors hired by the insurance company typically will give their independent view of what's going on, and will do that in light or with the idea that they will be able to testify down the road. There may be an arbitration, which is kind of an easier trial than a jury trial, perhaps. I mean, it's just a different setting. It's typically with an arbitrator, not with a jury. There may be a mediation, and a mediation is basically an attempt to resolve a case through settlement, where a mediator, a skilled negotiator, bounces back and forth from the plaintiff's room to the defense's room and carries these offers back and forth. Getting to the idea of damages, loss of earnings, lost earning potential. There's oftentimes a life care plan for a serious traumatic brain injury, where a life care planner will come in and will explain, for instance, what accommodations are required, what modifications to that person's house are going to help that person, what accommodations in their transportation needs are going to help that person, widening the doors, adding a ramp, buying a specialty van, things along those lines. And as you can imagine, all of these add up to very significant expenses, and so these types of life care plans are typically only taken when there is a significant enough pool of money through whatever the insurance source is to justify that. Otherwise, you would never spend the thousands of dollars for a life care plan if there was no reasonable way to expect that plan to be implemented. Now, I want to really be clear on the litigation process. As Lynn and I were just talking about litigation and trial, the whole process is very stressful. It's stressful for the attorney, it's attorneys, it's stressful certainly for the family and for the survivor. Go into that if you are ever, unfortunately in that situation with eyes wide open. It's not easy. And prepare yourself, steel yourself mentally as best you can for the long haul. Plaintiffs almost always expect this process to be over sooner, quicker than it ever is. It tends to drag on. Lawyers are notorious for delay. It just is something that happens from both sides, don't get me wrong.
Do you have any rough estimates of ranges of how long litigation?
Yeah, the question is whether or not I have an estimate on kind of how long litigation can take. It really varies from case to case, but I can give you some hard and fast rules. In the state of Oregon, we have a statute of limitations, and statutes of limitations exist in all courts, all jurisdictions, and that really means how long after the event that caused the damage do you have before you have to file a lawsuit in order to preserve that claim, and after which time, if you fail to file that lawsuit, your claim will be barred, meaning it's a hard line. If you wait too long to pursue a claim, you can lose that claim. If you pass that statute of limitations without there are exceptions, there's statutes of repose come in, things like that. So the first thing that I will want to do, I don't want to even try to resolve a claim until I know that my client has reached a stable medical condition. Stable medical condition does not mean that they have healed. Don't get me wrong on that. But stable medical condition does mean that I can look at that situation and understand the extent of those damages, kind of what we are looking for, what we can prove, what would justly compensate my client from both that economic and non-economic standpoint. Once I know that, that's when I really go forward into that negotiation process. I start by sending out a settlement brochure or settlement packet and it can take various forms, but it's typically a demand letter, typically 4 or 5 pages, maybe 7 pages in long cases. It will have all of the medical records. In the old days, it was always on paper, and we'd ship it out. These days, of course, it's all electronic, so we just have it on a disc. Medical records, as you can imagine, as anyone who and I'm sure many of you know, can be voluminous. I mean, you can get to where all of a sudden you have thousands of pages of medical records. And it takes time to review those records, not only for me, but also for the other side. And the other side has very skilled adjusters, very skilled actuarial experts. They have statistics on the other side. They know what common jury verdicts are in any jurisdiction, and they kind of play this numbers game, if you will, not a game, but this numbers analysis to pick this range where it's going to resolve, if it's going to resolve. And they need time to figure that out as well. I, on the other hand, have a competing concern in that I don't want to file this lawsuit if I think it's going to be filed early. Late. I don't want to file it near that statute of limitations. I want there to be plenty of time for me to fix the complaint if it needs to be, that I can get the other party served, etc. So realistically, if it's a complex case, I think that it would be optimistic to think that it gets resolved in a year, and realistic to think that it gets resolved within 2 years, unless it ends up going to a litigation process, and then you can probably add 9 months to a year on top of that. So it can be very, very slow and difficult. Question here?
What is the statute of limitations?
Well, again, I can't give legal advice, and so I have to steer clear from that, but I will just generally say that for the most part, in a personal injury type of situation, you're looking at 2 years. And I would encourage anyone who thinks they may have a case to consult with an attorney immediately. Lawyers are notorious for thinking that 6 months is around the corner. And please don't come to a lawyer's office with 30 days to go